Just recently, the Philippine Senate finalized its debate or hearing on the impeachment trial complaint against Vice President Sara Duterte. After long hours of debate, they ended up with a decision to archive it. As of this taping, there are multiple motions for reconsideration filed before the Supreme Court of the Philippines in order to reconsider its recent decision vis-a-vis the impeachment trial of the Vice President. In order to better understand what are the stakes as far as the Supreme Court ruling is concerned, what are the merits and demerits, and not to mention, of course, what are the implications of the decision of the Senate to archive its hearing and debate over the impeachment trial, we have a very special guest. Justice, thank you very much for joining us. And thank you so much also for this book.
You're welcome.
Silver is my gold. All right, there's a lot of metallic and no less than former Chief Justice Davide, former Chief Justice Panginiban, some of them we're going to talk about soon, recommended this, so I definitely looking forward to reading this. Thank you so much, Justice, for this. And as far as the alchemy of your life is concerned and the principles that has been driving your advocacies. Justice, before we go to your recent back and forth with Senate President Jesus Cordero, right? Because you took exception with some of the lines and certain claims that he made vis-a-vis you, ex-justices, making statements vis-a-vis what's happening right now. I noticed also in the Senate the other day, I was there during the debate, that, there was this, some were implying that, the reason why a lot of people are talking is because they have a specific political agenda. So before we go to the specifics of your responses to some of what you clearly believe are unfounded claims, can we explain to people what is at stake here with this Supreme Court ruling? Because I don't remember many times when you have so many ex-senior justices, associate justices, multiple ex-chief justices, not to mention leading law schools, experts. You also have the Solicitor General, the former Dean of UP Law, so many luminaries in the clearest sense of the word coming out and expressing disagreement. And at the same time, we're talking about an en banc decision. But we know that historically there have been cases like the ISAA versus Greenpeace, right, in 2015, whereby there was a unanimous reversal of a unanimous decision, right, when facts were presented. But Justice, can you explain to our audience what you found, let's just say it, defective, or what are the demerits that you found in the Supreme Court ruling, and what are the remedies that you have thought about? And how do you read the multiple motion for reconsiderations that have been filed so far?
Okay, essentially the way I look at it, the decision of the Supreme Court is concerns the accountability principle in the Constitution, where public officials are held accountable to the people at all times. And the mechanism provided in the Constitution to enforce that accountability is principally the impeachment procedure. And the decision in question touches on the effectiveness of that impeachment procedure as an accountability mechanism. To my mind, it threatens to destroy the effectiveness of that mechanism by imposing too many requirements in its initiation. And therefore, it should be revisited, because to me it's not necessary to impose those additional requirements in order to decide the case. We should practice what Justice Holmes calls economy of jurisprudence, decide only what must be decided, and decide every case on the narrowest ground possible. The purpose in that approach is to reserve for the future the issues that need not be resolved in the present case. So I think in this case, they should only resolve whether or not the once a year bar applies. Now, as to the need for due process, in the case of the second mode, where Congress itself is the one that files, and signs the articles, there's no need to add additional set of requirements for that, because you already said that the article is non-existent anyway, because it was not approved in plenary and because it ran counter to the one-year ban. So it is unnecessary to pronounce those things. That will only, if adopted, unduly hamper the effectiveness of the mechanism, which is accountability.
Justice, are you talking about, for instance, like this, I don't know, new requirement, the idea that the accused has to be there at the plenary or explain his or her side? I mean, how unusual, or rather how unconstitutional would be for the Supreme Court to, some would say, dictate or to introduce new terms and procedures for the House of Representatives, which last time I checked has the monopoly, constitutionally speaking, to actually initiate this process. Isn't that supposed to be the exclusive purview of the House of Representatives, how it conducts it? And in this case, your reading is that they followed their own rules, and it would be an overreach, perhaps, for others to say you should have this X and Y and Z rule. So can we talk about that? The doctrine of operative fact, or prospective overruling, has been also mentioned many times by different justices and experts.
Yes, Professor. If you read Article 11 of the Constitution, which is on the accountability of public officials, and Section 3 is on the impeachment as a tool for exacting accountability, you'll see that it lays down the procedure that governs the filing, initiation, and trial and decision of impeachment cases. These are a set of rules from subsection 1 to subsection 8 of section 3. I was the one who crafted those rules in the Constitutional Commission, so I'm very familiar with them. And these rules, you'll notice, is lodged as to the implementation and the crafting to Congress, to the Senate as far as the trial stage is concerned, to the House as far as the impeachment stage is concerned. The Senate and the House, under subsection 8, are empowered to adopt the rules to carry out more effectively this mechanism. Why the Senate? Why the House? Because they are not impeachable. You cannot impeach them. Therefore, they can draft the rules for impeachment. They will not be self-serving. On the other hand, the Supreme Court, the members are impeachable. Therefore, I say they cannot define the rules by which their own possible impeachment will be carried out.
Conflict of interest? Is that what you're implying?
That's against the basic principle of due process. No person can be the judge in one's own case. So I say for the court now to add a 7-point regulation rules, not interpretation, but additional rules to be observed in the process of impeachment, would be contrary to the basic, the cornerstone of due process itself. Because we precisely lodge this power outside of the Supreme Court into hands of people who are not impeachable. And therefore, they are not crafting rules that would benefit themselves. And yet, the Supreme Court was excluded from this rulemaking power, now wants to put the 7 set of 7 rules on the procedure. To me, that's improper. That cannot be done. That's amending the Constitution.
So, from a certain point, you could say it's not only an overreach, it could be potentially self-serving, to use a much more strident
It
phrases.
could benefit them because they are impeachable. And therefore, whether it's self-serving or not, they are not allowed to do it because of the principle of nemo, debet, iudex, and sua causa. No person, no matter how high, can be allowed to craft the rules that will govern his or her own removal.
And just to go back to the doctrine of operative fact, like this also idea of retroactively applying the rules that it seems the House of Representatives was not aware that they should have followed when they initiated the process of impeachment. Can you explain that for our audience who are not very familiar about the doctrine of operative fact?
The decision in question makes a new definition of the term initiate proceedings. And this new definition was not available, not known to us, to anybody, until this decision came out. So when Congress adopted the articles involved here, it followed the then prevailing definition of what initiating proceedings is concerned, which was laid down not by Congress, but by the Supreme Court itself in the case of Francisco versus House of Representatives. So for the Supreme Court now to adopt a different rule and apply it to the present case was, to me, unfair, because they could not have known this particular rule. And usually when there is a change in doctrine, the principle of prospective overruling is applied, and that new ruling or doctrine
Only
is
applies to
applied
future.
prospectively,
Yeah.
and not to the present case, especially if steps had already been taken under the prevailing rule, which is what happened in this case.
Now, Justice, let's talk about the facts of the case, because as we speak, another major TV network has made it absolutely clear that there seems to be some misunderstanding of the facts of the case here. And that's why a while ago we mentioned the en banc reversal in the case of the Greenpeace versus ISAA, because that was, my understanding, that was also a case of factual clarifications by scientists in that case that eventually led to some reversal, a very dramatic reversal of decision. In this case, many people are also saying that maybe the Supreme Court did not properly understand the counting process here, and more importantly, perhaps they did not even rely on the right source, i.e. relying on a news outlet source, which, by the way, is correcting itself, for them to understand itong one-year rule. Because we're talking about arithmetic here, right? We're talking about counting here. So it's important you get the facts correct and the counting process correct. What is your understanding that, because this is another alleged defect with the Supreme Court ruling?
The decision in this case says that, I think it's in page 47, that the articles adopted under the second mode by Congress by 1/3 vote was not approved by plenary. And therefore, it says it has no legal existence. Now, if that finding, which is a factual finding, turns out to be wrong or erroneous, then the conclusion that it has no legal existence, which is a basis for its decision and ruling that it is barred, that particular finding has to be revisited because, in fact, it would appear that it was approved in plenary. And the records, the journal of the House of Representatives shows that it was approved in plenary. And therefore, an oral argument can clarify this. And the journals can be presented to the court in order for the court to find what really happened in this case. And so that's one, the factual finding. I called it the factual underpinning of the legal conclusion. And that would alter the result if they consider the correct factual situation there. So that's one. The other is, of course, the imposition of due process. I'm not against due process, but what the court wants here is to apply due process in all the stages of the impeachment proceedings. And that is not what the Constitution requires. Due process is not required in all proceedings. It's only during the trial mode. And that is observed in the Constitution. But in the preparatory, there is a part that gives due process. That is the first mode, where the complaint is referred to a committee. And the Constitution says, for hearing, the committee has to have a hearing. That's due process. But that is not obligatory. Because there's a second mode that doesn't mention notice and hearing. And for the Supreme Court now to incorporate into the second mode a 7-set requirement of notice and hearing, for me, that is amending the Constitution. It's very clear that once 1/3 adopts the resolution itself, trial by the Senate shall forthwith proceed. There's no room for notice and hearing and trial by the plenary in the House. that is amending the Constitution. If that is the case, then the decision of the Supreme Court should be submitted to the people in a plebiscite so that it can really amend the Constitution.
So it's a de facto positive legislation in that case by the Supreme Court.
Not only legislation, but amendment of the highest law.
Right.
That needs a plebiscite. So what do we do? Put it to a referendum to our people. Do you agree with this decision? Because it amends the fundamental law.
Justice, what is your read of the, well, I know this is de rigueur, but the motion for reconsideration that was filed by the House of Representatives, but this was drafted by Solicitor General. Obviously, the Solicitor General works in behalf of the government, that is generally understood as the lawyer of the executive branch. I mean, that's one way of understanding it.
Yes.
But nevertheless, one thing that many people noticed is it seemed quite very constructive and conciliatory, right? The tone, the cadence, and the way it was structured was, many people found as very elegantly providing a room for, some would say, an off-ramp here. Because my understanding is that a couple of ex-justices, aside from yourself, for instance, ex-Chief Justice Panginiman, for instance, said, maybe we have rushed this a little bit. Maybe you want an oral argument first, right? Are we in a situation whereby we're having de facto oral arguments now via those motion for reconsideration, and therefore the Supreme Court has to give this a bit more of time? I mean, what is your read of the MRs? Are they...
In fairness to the Supreme Court, I think it is in the process of preparing the case for an oral argument, because it has required the petitioners to comment on the motion for reconsideration of the House. And usually when the comment is filed, there are issues are joined. The court either requires memoranda to be filed or schedules oral arguments for a fuller ventilation of the issues involved. So I can see that that's the direction that the court is heading towards, and that is very good. And I hope they do call for oral arguments so that all those issues, including the factual underpinnings of the legal findings, can be threshed out in fairness to everybody concerned. And I would say this, that after hearing all sides and the Supreme Court still maintains its decision, let's abide by it, because they are the final arbiter of the Constitution, what it means. Even if, to my mind, they have amended the Constitution. But that's me. I'm not the final arbiter. Supreme Court says this is what the Constitution means. Then let's abide by it. And if we want to change it, we have to change the Constitution the proper way.
Which brings me now to the Senate, right? Because the big debate in the Senate the other day was that has the Senate lost jurisdiction because of this ruling? Meaning the trial to begin with was faulty, therefore the whole thing should just go out of the window. Some were arguing that the Senate should move ahead because at the end of the day, the prerogative is with them on this issue. They have the sole constitutional mandate to conduct trial. And then there was a kind of a splitting the difference position that was forwarded, and I'm not sure if it won or not because it depends on how you understand archiving. The idea was that let's just wait first for these de facto oral arguments to be considered by the Supreme Court. And then when final, because the executor part is there, yes, but it's not final yet, right? So I don't know why people cannot understand that. It is true that it's immediately executory, but it is no longer final from my understanding because there's
not changeable.
Exactly. Yeah.
It's executory, but still changeable.
Changeable, exactly.
Yeah.
Still changeable. So, what is your understanding of the debate in the Senate the other day, and also the way the Senate leadership, in particular, not only took exception with you, but tried to kind of explain their decision to archive, which is, again, I know it is within the purview of the Senate to come up with their own ideas on how to proceed with things that are within their constitutional purview. But we heard remanding last year, and then now we're hearing archiving a trial. Like, for some of us who are not very familiar about the internal rules of the Senate, it kind of looks like these are new inventions, or there's still confusion about that. So, first of all, Justice, what is your read of the debate that happened the other day? And then, importantly, what does archiving mean? Does this mean the process has been frozen and de facto being given a chance, in a sense that we're waiting for the the final decision of the Supreme Court before the Senate can decide on this?
Okay, I first presented three options that, to me, the Senate has with regard to the decision of the Supreme Court. Option number one is to do nothing and wait. Wait for the court to finally
Deferral.
yes, resolve the pending motion. So just wait. Second is to go ahead and try the case because that's its prerogative. And that would violate, however, the immediately executory nature of the Supreme Court decision, and that could present a constitutional crisis. So I said that should not be done. The third is to dismiss the articles. And I said this is problematic for two reasons. Number one, the Supreme Court may still change its decision. And if it changes its decision and say that the articles were after all valid, then what will happen to the Senate's dismissal of the case? It would look awkward. And number two is that the Supreme Court itself may then find the matter moot and academic,
Yes.
and therefore will not be able to resolve all those pending criticism against its decision by ruling on the motion for reconsideration. The other thing is the Senate could not really dismiss the articles because remember, it returned the articles to the House,
Right.
and it's still there, and it's waiting for the 20th Congress, House of Representatives, to send it back with the confirmation that they are willing to prosecute it. So you cannot dismiss what is not before you. So it is good that they did not dismiss it because that would have been...
But there was a motion by
there was
Senator
a
Mark
motion
Orletta.
to dismiss, but
Yeah.
it was amended to want to
Archive.
table it.
Yeah.
There was a move to amend the motion to dismiss to table the motion. And it was not tabled, but instead the motion to dismiss was amended into a motion to archive. And that was carried. And 1941. And I feel that that was a good move. Why good move? Because it did not kill
Did not
the
dismiss,
articles.
yeah.
It's still alive, only it's set aside. Some say in coma. Hindi naman siguro in coma. It's just sleeping perhaps. Archive means set aside but can be retrieved. Okay, so why is it good? Because the motion for reconsideration in the Supreme Court is still alive. It's not mooted by the archiving. So the Supreme Court can proceed with oral arguments and can proceed to revisiting its decision and can proceed to reconsidering it if necessary. And in the event that it says that the articles are valid and trial can proceed, the Senate can recall what it has archived and obey the new decision of the Supreme Court. So it's a good move.
That's interesting because I think a lot of people were very alarmed when Senator Tito Soto said, ang pagkaalam ko parang archive is dead na. And we were not very sure about that because the motion to dismiss was defeated. So my understanding is the archive is, how should I put it, is a very Escudero way of splitting the difference, right? It's like in diplomacy, right? Let's find a compromise within a compromise so that we give time for future agreement, right? I kind of saw it that way. Because after all, this is not a purely legal matter. This is a political process after all. So people have to understand there are layers upon layers to this. Having said that, though you have welcomed the archiving as preferable to the other two scenarios of triggering a constitutional crisis or dismissing this altogether, which would have made a subsequent Supreme Court final ruling as either moot and academic or potentially even contradictory, what is the exception you took in particular with Senate President Jesus Escudero? Because this has been all over the place. I think what rankled some people was this implication that a lot of you folks from the outside who are criticizing this ruling or pressuring the Senate are supposedly politically motivated, or that in the past you yourself were not following the very things you're preaching. So for the sake of the audience, what was the clarification made? I think this had to do with Chief Justice Davida's case, right? So what is the precedence for ex-justices disagreeing with the current ruling and what are the norms around that, perhaps? Yeah.
Okay, both Senate President Cheese and I were involved in that case of the
Yeah.
BIDE. I was in the Supreme Court, and he
Right.
was in Congress.
Right.
And he says that in that case, we issued a TRO and stopped Congress from transmitting the articles to the
Right.
Senate.
Right.
Now, I corrected that because, as I recall, we did not issue a TRO. What we precisely refrained from issuing a TRO because we did not want to trigger a constitutional crisis by ordering a co-equal body to do something. So we discussed how can we stop the transmission without ordering.
Without
House.
ordering. That's important.
Without
Without
the
ordering.
TRO.
Yeah.
So I was the one who crafted the language of the
Yeah.
resolution, which Chief Justice Puno said it was the formula that saved the nation, according to him,
Right.
in our deliberation. And the resolution merely said that we call on all parties. All parties, kasama na yung House doon. There were other parties. So we said, we call on all parties to maintain the status quo, to allow the court
Right.
to resolve the issue, constitutional issues involved. That's all. We did not order. We appealed. We urged them to maintain the status quo. And when this resolution was received by the House, the Speaker of the House assembled the House and said that in view of this resolution from the Senate, I am constrained not to transmit the article to the Senate.
Yeah.
And therefore, unless there's any objection, we hear none, the articles are not transmitted, the session is adjourned, and then he banged the
Right.
gavel. Perhaps to the other members of Congress, they thought there was an injunction because he said he's constrained. But what constrained him was the appeal
Not
to
an
maintain, not
like-
an order,
Not an order, but more
but
of
an
an
appeal,
Yes.
a request, a plea to maintain the status quo.
Right.
So I'm constrained, bang the gavel. So that's what happened. There was no TRO. Secondly, that case involved a different situation because all the Supreme Court did there was really interpret the phrase initiate proceedings and said the rules of the House moved that time frame much later than where it should be. So it would do more damage than
Right.
what the rule 1-year ban intends, which is to prevent too much disturbance, both on the part of the respondent official and the part of the House. So the court felt that we could move the time to triggering time earlier, and they said it should be from the time it is filed and referred to the committee. That is initiated. The rules kasi said, the House then, that initiated upon voting of the committee.
Right.
So much later. But sabi ng Supreme Court, the rule said, at that time it's deemed initiated. So, ibig sabihin, pwede pang earlier initiated by the time deemed initiated na.
Right.
So, the interpretation of the court was upon the reference to the committee. So that's still interpretation. We did not introduce a set of 7 rules for the House
Yeah.
to follow. So that's different. I voted in favor of that. It's interpretation lang. I would have voted against this because this is adopting rules which were explicitly given exclusively to the House to frame.
Well, that was a more direct, I would say, attempt by the Senate President to basically try to undermine the line of argumentation you have put forward, to be frank about this. Now, we had other senators, or at least there was at least one more senator who was making a lot of blind items, including against yours truly. That was very obvious. But the argument you're also hearing from certain people, I mean, for instance, Senator Cayetano, he said something like, basically was saying, is this really about Sara Duterte, or is this really about the rule of law? And the implication or the argument he was trying to make was that it looks like many people are so invested in this because they just want to remove Sara Duterte from office. And the denouement of that line of argumentation was, talunin nyo na lang sa 2028. Which I found extremely troubling, that line of argumentation, because the rule of law is not supposed to be a popularity contest. And to make it even more cynical, I'm not sure our elections have been a very good indicators of making sure we get rid of problematic characters, to put it nicely. But more importantly, separate yung electoral exercise from, right, criminal liability or being held accountable, right, for abuses that happen. This should not be subjected to cycles of election, right? So, first of all, just to be clear, your intervention has nothing to do with political inclination or persuasion,
Nothing.
right? And more importantly, isn't it so problematic for some to just say, ano, idaan na lang natin sa election, basically sa popularity na lang ito, huwag na natin idaan ito sa proseso, sa legal processes. What is your take on that line of argumentation?
They are forgetting one phrase in the Constitution. Public officials must be accountable to the people at all times.
At all times.
Not only election
During election
time.
day, yeah, exactly. Yeah. We're going to the latter part of our discussion. And I want to also go to your book, and maybe you can also suggest people to check out your memoir. Let's talk about the Supreme Court as an institution, right? What makes the Supreme Court unique is that it's a merit-based institution in a way that the other branches are not. I'm not saying they're not merit-based, but it's merit-based in a very specific sense of the word. You guys are not elected through elections, right? You're not elected by popular vote. There are systems in other countries whereby dadaan sa Senado, for instance, in the US, right? Before it's not direct appointment. So you go through a certain judicial procedure, and based on your merit, you end up as a justice in the Supreme Court of the Philippines, right? And therefore, people would argue, this argument has been made in the case of the US, but I would say it's even more poignant in the case of the Philippines, is that the ultimate authority of the Supreme Court comes from that respect and authoritativeness they enjoy. So what I want to understand is that with so many of you ex-justices coming out, how are you contributing to the preservation of that authoritative nature of the Supreme Court's ability to preserve our constitutional democracy and order? Because some would say, maybe not only this goes against collegiality, but you are contributing to undermining the... Well, some of us have been even accused of indirect contempt for... So what I want to understand is that, where are you coming from as an ex-senior associate justice, Justice Azcuna, on this?
Okay,
and how are you helping
are,
actually to preserve the Supreme Court's place in our
Yes.
constitutional order?
So very excellent points that you raised, Professor. First, in Angara versus Comelec, the Supreme Court explained that when it says that it corrects one department, says that this department is correct, that department is wrong. When it says that, it's not making itself superior to those departments. They are co-equal. What it is saying is that the Constitution is superior to them all.
To them all, yeah.
It's just applying the Constitution. So when the court applies the Constitution, it's not because it is superior to the other bodies. It's because the Constitution is superior to them and to everybody. So that's one. That is the role of the Supreme Court, to see to it that everybody observes the Constitution. Secondly, when I was about to retire, I attended a conference in Hong Kong,
Right.
sponsored by I think Oxford University, on common law.
Right.
And I found out why our Supreme Court, which is not elected, is made the guardian of fundamental liberties.
Wow. Right.
Why is the Supreme Court, na hindi man lang sila tumakbo as kumukonsihal,
Right.
are empowered under the Constitution to protect the fundamental rights of the people? And the reason I found out was precisely because they are not elected. They are not majoritarian.
Right.
They are not responsible to the majority. And fundamental rights are often violated by the majority.
So counter-majoritarian.
So they are, yes, counter or non-majoritarian. They are not indebted to the majority. so they can decide against the majority to uphold fundamental rights. That's why fundamental rights, including due process, is given to the Supreme Court. So that is why, that is the issue here, whether or not there has been a violation of the fundamental right of due process. And that is within the power of the Supreme Court to find out. And that should be done after full hearing, because that's part of due process also of all the parties.
Justice, before I ask you again about your book and a little bit about you, because this conversation reminds me of the interview I had with Prime Minister Mahathir when he was here in Manila a few years ago, and I asked him how did he keep so sharp and strong throughout the years, and knock on wood, I'm very impressed, Justice. So maybe we can get some tips from you in terms of anti-aging and keeping strong. But just last important question I wanted to squeeze in here. So, like in political science and even journalism, we have questions of what we call loyalty effect, or what could be the implications of direct appointment of justices by a certain executive, in this case, president. In the case of the U.S., it still goes to the Senate, right? There's a hearing, etc. So there's a very robust literature about the so-called loyalty effect, and yours truly got into trouble apparently because some people misinterpreted that or maliciously reframed that as if I'm questioning the integrity of the court. But as a political scientist, my argument is that this is a legitimate discourse. There are authoritative journal articles on this issue and studies also by the PCIJ. Again, as a man of the court, as a person who stands for the rule of law, why the case of the Philippines is like that there's a direct, I mean, I know you go through the, there are secondary processes, but shouldn't there be an aspect of, like in the US, hindi ba dapat dadaan ang appointments through other institutions? Shouldn't there be more popular involvement in the appointment of justices? Or you believe the current system is working and that it's unfair to make any inferences because a certain president appointed a certain people, therefore there could be certain so-called loyalty effect? Again, this is a debated topic. So you're no longer in the system, right? You're an ex-justice. But what is your read of that kind of debate? Because it is a debate out there, and
Yes.
people talk about, ito kasi in-appoint na ganito, ganyan, or loyalty effect, or utang na loob. Again, this is not though to cast aspersions on the integrity of the institution, but I'm just saying this is a discourse out there, and it's debated within the academic context.
I think the system we have, it's a good system. Maybe it can be improved. But basically, we have a system where the appointment of the members of the court is no longer passed through a political body like the Commission on Appointments, but we chose a professional body, the Judicial and Bar Council, to select the nominees. And the president can only appoint from the list, so limited the choice of the president. And once appointed, hopefully the members are independent because they have a fixed tenure. And they can only be removed by impeachment, although someone was removed by quo warranto, but that's another story.
That's a very long story.
That's another story. And that their budget cannot be decreased during any time. Their salaries cannot be decreased. So they are given fiscal autonomy. So there are a lot of guardrails to ensure that even if they were appointed by the president, they will not be beholden to the president. When Cecilia Munoz Palma was about to reject appointment as justice, she consulted, I think, Tiangki, and Tiangki told them, no, you accept it because after you accept it, your loyalty is not to the appointing power, but to the Constitution.
Right, yeah.
So that's the situation. And I think we have to abide by that, and we have to give it to the incumbents to say that what they did here was not because of the appointing power, but because of what they truly feel the Constitution requires.
And Justice, of course, corollary to that point that they raised, and I don't want to be self-serving here because there are multiple people of being accused of indirect contempt. Like, what is your understanding of a fair and constitutionally protected freedom of expression around discussions of the Supreme Court's decisions. Because we live in a country where people openly attack the president, accusing of the worst things without any basis. The most salacious stories are spread about them. We live in a system whereby senators are criticized right and left. Even their eyebrows is made fun of right and left. And yet we don't see them, filing contempt cases or anyone filing contempt cases in their behalf. Why is the case of the Supreme Court? Where does contempt start and where does freedom of expression end? Or is that something that should be negotiated and balanced over and over again? Because if I recall, no less than Justice Leonen has emphasized throughout time that hindi dapat onion skinned ang justices, and there has to be a certain degree of tolerance for criticism, even though sometimes it might get a little bit spirited and passionate. Again, the reason I'm saying this, Justice, because it's related to the question I raised a while ago, which is the exceptional character of the Supreme Court as a body which is not elected, but gets its authority from a different kind of lane.
The idea of a contempt, there are two kinds of contempt. Direct contempt is when
inside the court you're making noise,
yes,
and then
you are physically preventing the court from doing its job. That's direct. Indirect contempt is something that produces the same effect without actual physical disturbance. Maybe words can be more hurting than stones sometimes. So it depends on actually the perception, both of the public and of the court itself, as to the effect of these words that are hurled against it or its verdict. Is it something that would impede the administration of justice? And that I think is the bottom line. Not whether it will hurt their feelings, but whether it
operationally,
will adversely affects the administration of justice.
Right, obstruction of justice.
That is then if it's just their feelings that are hurt, but doesn't prevent them from administering justice. I think they can take it, and I hope they can take it.
I do certainly hope,
Yes.
and as we speak, my legal team is forming our response. There's no show cause order. Now, the most important part of this conversation, Justice, and I really look forward to it because, I remember you from my younger days. Actually, we're related to former President Arroyo. She's our distant tita and all that. And I think you were appointed during President Arroyo's, right?
President Arroyo.
I remember very well from those days, and I was just telling folks wow, I'm so impressed by the strength and lucidity you bring in. So, are there also advice on diet and how to keep the mind fresh and strong, Justice? Is there a specific advice you have to other people who have lived such an intense and prolific life like yours, and how can they keep on staying prolific aside from going on podcasts or TV shows with people like me?
I think attending interviews like this, in other words, keeping oneself mentally active is one way. Not to stop.
Is there a specific coffee or drink or reading routine that you do you go back to the Constitution every other day?
Yeah.
How do you keep it so sharp, Justice?
Not really anything unusual. Just keep on exercising your faculties.
Right.
As they say, happiness is the exercise of vital powers along lines of excellence in a life that affords them scope. That is the prescription to be happy.
Thank you so much. That was a very kind of Roman Republic statesman kind of advice. So again, Silver is My Gold, An Alchemy of My Life by the Principle of Magis by Adolfo Azcuna. Thank you so much, Justice,
Thank you very much,
this
Professor.
kind gift, and looking forward to reading this. And please continue. I hope to continue to join us, whether contemptuous or not, as long as we're not contemptible.
Yes.
Thank you so much, Justice, again for that
Thank you
discussion.
very much, Professor.
Thank you.
My pleasure.
Catch us again next week here on One News. You can also check out the long conversation on YouTube and Spotify. I am Richard Haydarian, and that was a View from Manila, where One News, all sides, all the time.